analyst Mpumelelo Zikalala. Mpumelelo, a good morning to you. Thank you for joining us. I think we're going to get into some of the delays and what you make of where we are in the trial, but I want to just start with a reflective point, right? 10 years on. I mean, it's hard to believe that it's been 10 years, but when you think back to that day, the country was completely in shock. Did you think that we would be where we are 10 years afterwards, a decade later?
Good morning to you and also to your viewers. Not necessarily. In fact, I must say no. If you look at the type and the caliber of the mechanisms and the legislation that we have, the type of law enforcement agencies that we have, we ought not to be here 10 years on. But one needs to be grateful to say at least there are answers which are going to be answered, or that some of them has been answered 10 years later, even though it has taken a decade for that to happen.
Yeah, that's an interesting point, because the family certainly would agree that 10 years later they should have been justice by now for Senzo Meyiwa. Give me your thoughts as to why we still haven't gotten there. What is it that's gone wrong?
I think we must separate the two processes. Let's start with the law enforcement agencies, because that would be the police going to investigate. There's still a lot that needs to be done in terms of training, how evidence should be collected when it comes to the intelligence that we ought to have, how evidence should be kept. And the second part of it then goes into the prosecution part to say, when it comes to the prosecution, what are the things that need to go on and our courts that need to reform by so that we're able to get those speedy conclusions to matters such as these ones. With law enforcement agencies, if you would listen into the police officers that were first to be called on the scene, they've made many mistakes. Then the question would be, have we trained our police officers to make sure that when they are the first to arrive on scene, they're the first to collect the evidence, which is going to be later utilized in court? When it comes to the investigation, have we trained them properly so that at the end of the day, when they are going about collecting that information, there's no poking of holes which is going to take place at a later stage when evidence is presented in court. And then you go into the court system itself to then say, do we have a court system which is accommodative and that promotes speedily conclusion of cases? For example, simple one, we start at 10 and we end at 3. You and I will start work on an 8-hour basis earlier in the morning. So there's a plus 2 to 3 hours which is lost purely for no apparent reason. Then secondly, if there are certain cases that have been long outstanding, what is so hard by saying that let's even work on a Saturday, maybe start at 9 and end at 3 on alternative Saturdays, and make sure that we're able to get those speedily cases to be resolved within time. So it is small things that need to be catered, that need to be accounted for by both our law enforcement agencies and the court administration to make sure that there are no delays which are going to take place.
Yeah, I want to focus on the latter, and I think we will possibly get to law enforcement and what police do after the murder. Or have done in the case of Senzo Meyiwa. But I actually want to look at this. Judge Edwin Cameron actually wrote a piece which looked at justice postponed, what causes unreasonable delays in criminal trials. And I want you to hear this out. One of the things that he writes alongside co-author Alexia Katsaginis in this piece, he writes, tactics of delaying trials include meritless applications, failing to appear and applying for unnecessary postponement, sometimes stunt withdrawals by defense lawyers or the accused to stunt dismissal of a defense team feature. To expose these tactics may be difficult, but suspicion often exists, and some criminal legal practitioners collude with clients to use supposed unavailability to get postponements. I mean, is this something that we've seen riddled with the Senzo Meyiwa trial?
Definitely. There have been a number of postponements that have taken place, whether they have merits or not. I think later on that question is going to be answered. But when it comes to the manner in which the matter has been handled, after Judge Rata came into the form, I think he has managed to say, I'm not going to tolerate any postponements which are going to be there that are not necessary. Yes, my hands are tied in terms of denying them or allowing them to continue, because at the end of the day, the element of justice says that I must give you an opportunity as the accused to make whatever application that you want to do. I can't muzzle you off or close you off. I must hear what you say, but I'm going to entertain it and make sure that the ruling has been issued. Also, I do not want to change the case so that when it goes on appeal, the mere fact that you were not given an opportunity to make those applications is viewed as if your trial was riddled with injustice and that there's a mistrial which is going to happen. So it's one of those things that have to be carefully looked into. But then the question should be, as the NPA, and just the prosecution side and also our courts, How prepared are we so that we're able to deal with those type of applications? Is our case solid tight so that we do not have those applications creeping up? And then how do we deal with them so that even when there's a postponement, for example, because the legal practitioner is sick, the minute they come back, you then say to them, where's your doctor's note? I want to see that doctor. They must come here if the case it might be, so that they're able to say it is really authentically a position that you are not available to render your services, hence why a postponement has to be through. So it's the thoroughness that needs to be applied by the presiding officer who's tasked with making sure that the trial goes on without any delays.
Yeah. Is there something in our legislation that speaks to trial time limits? Is it time to have that discussion?
No, there's nothing at the current moment. That discussion, yes, I think it's time that we start to speak about it, because one of the things that is going to cause us to do is to investigate as to what are the delays and what causes those particular delays. Is it purely the procedures that we are following? Is it the legislation that is there? Or it is purely the lack of innovation that is there in the way in which we manage our courts, in the way in which all these court proceedings are then conducted? If we can able to deal with those and look and delve deeper into that one, I think we'll be able to come up with solutions to say, in order for us to have speedily trials, this is the things that we need to engage in. These are the process that we need to do, so that at the end of it, we do not wait for so many years in order for the trial to conclude.
All right, so let's talk about the arguments that have been put forward here. You've got, of course, the state wrapping up its, string of witnesses that have taken to the stand. Your understanding of what should take place next?
Well, there are a few options which are available to the defense. Firstly, they can apply for what we call a Section 174 application that says, I want to dismiss this case from the instance. Yes, we've heard the evidence, but nothing is linking it to our one of my clients, of which in this case, I don't think that application would succeed. There are a number of things in which all the accused that are in the accused box need to answer to, and there's some explanation in which the courts would want to hear from them. The second one is, which I think probably they will do, is then to say, we are going to go into the stand now. We are going to provide our witnesses, and we are going to also testify on our own to try and justify or provide answers as to the allegations that have been leveled against us. If you look at the number of the accused that are there are 5. And if you estimate that maybe each of them would spend maybe 3 to a week, you are looking at plus minus another month and a half before the matter is concluded, provided they don't provide any other witnesses which are going to corroborate the statements or the evidence that they're going to provide in court.
If the defense does call witnesses, who do you expect would be called?
Well, I think the mere fact that they wanted to know about the second docket, there may be subpoenas that are going to be issued to say, we also want to call all the other individuals that were in the house, with the hope of doing 2 things. Either they can eliminate the presence of their clients, that is the legal practitioner representing the accused, or they can come back and say, I want to poke holes in the inconsistencies that are there to try and show that one set of witnesses that were in the same house are saying something which is totally different from the ones that were there. And you would know that there is a name of a certain person of interest, which is Ms. Kelly Khumalo, which I think, if given an opportunity, maybe some of the accused would say, we want to subpoena you, come and give evidence. You will be able to shed some light as to what is happening here, especially because we are one of the individuals that were not called by the state, even though you were in the house with all the other witnesses that have been called in.
It certainly doesn't help that at some point during this trial we were hearing, and it was during the trial within a trial, and that again speaks to just how long of a process we've been watching in the Pretoria High Court. But in that time, we also heard the name of Kelly Khumalo being put forward as an alleged mastermind here, right? So, I mean, if she is or is not called, are we looking at an injustice here?
No, not necessarily, because an injustice will only happen if there's evidence pointing towards her, even after the completion of this case, and that she's not called. It may be the strategy of the state to say, we want to go on a win-win basis. Let's start with the people, the foot soldiers that were on the ground, the people that entered the house, the people that executed the killing. We can then come back and deal with the alleged masterminds behind the whole process and the individuals that would have benefited from it, to then say, after we've got a conviction of these 5, this is how we are going to use the evidence that has been collected there. In fact, what the state has done is to try and unravel where they are going without being direct as to those the accused that they are after. Another thing that you must remember in this point is that when you go to court on a criminal basis, you must be able to prove beyond reasonable doubt that the individual that is in the accused box is guilty. If you are going to find certain loopholes and questions that have not been answered, it's going to be very difficult for you to do so. And the better thing to do is to then say, let me deal with the ones that I have now. Let me deal with the foot soldiers if I have them, because I have their fingerprints, I have their presence in the house, and they're not going to be able to answer any contradicting explanation that may be there or provide any explanations. Once I've got the 5 that are convicted, then I can be able to move on and say, what was the motive behind this whole process? And let me find the mastermind and also make sure that they're also punished.
Sure. So many details to really be thinking about, and it certainly speaks to the complexity of the case. I think let's wrap this up. And you may have touched on this answer a little bit earlier, but I just want to get clarity on your position on it. Let's say the Senzo Meyiwa or the Meyiwa family is watching this conversation, and 10 years on, they're reflecting with broken hearts, and then they're wondering, how much longer? How would you answer that question?
I would say, while being optimistic, I'd say maybe by the end of next year, 2025, by June, because remember, we're going into the December recess. I don't think they'll be able to complete the evidence before then of all the 5 accused. But if we are really being optimistic, by the end of next year, 2025, maybe the trial will come to an end. If there are any other delays which are going to be there, maybe the calling of witnesses which may no longer be there, or maybe staying afar, we may look at the year 2025 starting and ending without that this matter being wrapped up. Maybe in the earlier part of 2026, only then we can come back and say there's a judgment, there's someone that has been convicted, or there's someone that has been acquitted in this matter.
It would be sad to be sitting here next year and saying 11 years since Senzo Meyiwa's death, and his family still has not seen answers or justice. But Mpumelelo, we really do appreciate your time. Thank you so much for speaking to us. Mpumelelo Zikalala there, who is a legal analyst. And in our poll question, we are, of course, looking at today marking 10 years since Senzo Meyiwa was killed. It was on this day a decade ago. We're asking you if you believe that justice will be served, right? The answer, the options there are yes, no, or the trial is dragging. Engage by scanning that QR code on the side of the screen there with your camera. It should take you directly to those options. Vote. And if you'd like to send your comments as well, at Newzroom 405 using the hashtag Weekend Report.